Time leave to mention a matter for inclusion, 24 matter lack.
Lordship,
Yes, yes, sir.
may I be permitted to mention one matter for inclusion, Lordship? It was earlier filed before Honorable Justice Om Narayan Rai, but it was released by His Lordship due to wrong determination. The matter pertains to Group 1 matter, Lordship.
Motion matter.
Yes, Lordship. Grateful.
My lord, may I be permitted to mention one matter, my lord, for extension of interim term
When it is expiring?
on 30th June, my lord. My lord, I have already filed CAN.
30th June.
I have already filed CAN application.
You have already filed?
Filed CAN application for extension. Another application.
Well, under the heading extension, have you served?
Yes, yes. Notice. I have already served.
তাহলে একটা কাজ করো next week এ তোমার ওই 8 কিংবা 9 জুলাই extension of interim order নিয়ে আসো।
My lord, I am saying for inclusion in the list, my lord. Petitioner is a land loser. Hearing matter in any
Hearing matter?
my lord. My lord, only inclusion in the list.
Monthly yes.
Lordship, may I be permitted to mention this land matter for inclusion in the daily cost list? It is the petitioner's land was acquired for construction of highway in
Is it a motion
1960.
stage? Motion stage or hearing?
Motion, new motion. Grateful.
Yes, call the list.
Lordship, excuse me, Lordship. In spite of your order for hearing this on this day,
It will be listed.
and I met with those officials.
It will be listed today at 2 p.m.
2 p.m.
Mistakenly, it was not listed. দুটোর সময় হবে।
Lordship, I beg apology. I wish to say that my ticket has already been reserved, so it may kindly be for Friday.
আজকে চাইছেন না?
আজকে স্যার আমি বাইরে যাব একটু, খুব জরুরি আছে।
ফ্রাইডে?
হ্যাঁ, ব্যাঙ্গালোর যাব, একটু প্রবলেম আছে।
ফ্রাইডে চাইছেন?
হ্যাঁ হ্যাঁ,
ফ্রাইডে দিয়ে দাও।
স্যার
তাহলে লিস্ট করো না। এটা আজকে আসার কথা ছিল তো?
লর্ডশিপ,
ভুল করে আসেনি। It will
লর্ডশিপ,
be listed on Friday.
লর্ডশিপ।
10:30?
Yes, yes, লর্ডশিপ।
10:30 দিয়ে দাও।
Regards, লর্ডশিপ।
For judgment.
It thus appears to this court that the review petitioners have miserably failed to establish any error which is apparent on the face of the record in the judgment dated 8/2/2024 as passed in WPA 11914 of 2021. Stop. It thus appears to this court that the review petitioners have miserably failed to canvass any of the grounds for review under Order 47, Rule 1 CPC. With the aforementioned observation, the instant review petition is thus dismissed.
One indulgence, but in
Yes, can have no file din.
এটার যে ক্যানটাতে তাদের যে এন্ট্রি অর্ডারটা ছিল কনসিকুয়েন্সিয়াল অর্ডার্স, money is lying with the Registrar General.
With that regard,
On that calculation, on the basis of the calculation furnished by them, that the Registrar General will not liquidate the bank draft.
Your Lordship, with
Let
that,
me go through the file.
My lord,
Sir, I cannot recollect everything.
my lord,
Order
order,
I do.
my lord, order dated
CPAN is not in the
18th
list,
February.
Your Lordship. The
No, no,
CPAN
no,
is
not
in the
seek and
list.
review.
Let the matter be. placed
Order
on-
dated 18th February 2025. Paragraph 15, 16, 18.
CPAN is not listed today.
Yes, CPAN is not listed today, Your Lordship, and that order was.
No, no,
passed
it
in
is,
the
it
CPAN.
is in the review.
That order was not passed in the
You know,
review.
it is in the review.
Your Lordship, I have
No,
a,
it was
I have a
in the
statutory
review.
remedy under
My lord,
appeal.
kindly
What
see.
my learned senior friend is telling.
No, no, I am praying before Lordship kindly have a
Your
patience.
Lordship,
I am making submissions. It was filed.
Your
It was,
Lordship, I pray
it
for
was-
the stay of
it
the
was-
judgment for 4 weeks.
my lord, it
I
was
have an appellate forum. I
the
should be
paragraph
allowed to
15.
exercise
my
that.
lord, paragraph 15, 16 and
The money
18.
is lying secured. I have
Not
shown my
all at a time, sir.
My lord, your lordship kindly comes to your lordship's orders dated 18th February 2025. Where the
18
in
February.
2025. There was a CAN in connection with the review stay petition,
Paragraph number
paragraph number 15.
15.
Yes, starting from paragraph 12, where they prayed for stay of the impugned order in review, not in contempt. starting from paragraph 12, operative portion, paragraph 15, 16, and 18.
Now your lordship comes to page 171. Now your
Then
lordship,
I am to vacate this stay order.
Yes, yes.
your lordship kindly sees page 171 once. Now let me have my audience.
Yes, sir.
Kindly comes to page 171.
Page 171.
Yes, yes, of that paper book. Page 171.
The order I am referring. Lord.
The order, the first page of the order. The first page of this order. Your lordship, there was a contempt pending. We filed a review. Your lordship was pleased to show bona fide. In the contempt proceeding, the amount was deposited.
No, in review
Your
petition.
lordship, I did not interrupt. Let me make my submissions.
Yes.
Only placing 3 paragraphs won't help. The matter was taken up analogously, the contempt and the review. To show the bona fide to this honorable court, the amount was secured to the learned registrar. Now, the contempt was also listed. Kindly see the order, the first page, contempt and the review. Moreover, first, secondly, your lordship, to show bona fide in the contempt proceeding, we deposited the amount.
Order for depositing the amount while entertaining the order of stay was passed in connection with Can 2 of 2025.
So, your lordship, my second submission
Yes,
is
sir, please. So Can 2 was filed in connection with RVW 8 of 2025. Now,
RW is dismissed.
review has been dismissed. Now I am to fix a date for CPAN.
And in the meantime, your lordship, this is my humble prayer. Kindly give me 2 weeks at least before that demand of liquidated, so that I can exercise my statutory remedy. Only 2 weeks.
No appeal dies.
RVW the liquid. RVW. The panel.
Lord, I appeal for the petitioner. Last occasion, my lord, I am sorry, my last occasion I am not appear. I failed to appear, my lord. This matters, my lord. Pursuant to the my lord's direction, my lord, I filed my report, my lord. Report is ready, my lord.
To be mentioned. Detail. Correction কি আছে?
There is a previous direction, my lord. File a report in the form of affidavit, my lord. Report is ready, my lord. If my lord's given liberty to.
So the matter is listed today under the heading to be mentioned. তাহলে লিখে নিন আরেকটা প্যারা অ্যাড করে নিন অন কনসেন্ট অফ বোথ
So 18-20 paragraphs have been written. With
what is your
annexes.
prayer?
Lord, my prayer, my lord, in the writ petition stands, my lord, today what happened, my lord, I had a land, my lord, under the water jal scheme. My lord,
Consider the representation. What representation you have made?
my lord, my representation is, my lord, today, my lord, they take my land saying that we will implement a jal scheme. Now, my lord, they asked me to, my lord, they inquire my land, give a certificate to me, my land is fit for this scheme. And then, my lord, wrote me a letter that for that a deed has to be executed between you and me. Now, my lord, pursuant to such letter, my lord, I execute a deed with them.
Deed of gift.
Deed of gift. My lord, after execution of the deed of gift, they sat tight. I wrote them a letter. What about the jal scheme for which you made me execute this deed of gift? Certainly, my lord, on my inquiries to an RTR reply, my lord, I find that the scheme is now being operated in a different land of a different person. Now, my lord, as well as my land is shown in that RTI where my land is found to be fit for that jal scheme. But and the records also show
You
that.
want return?
Now, my lord, yes, my lord, kindly sees, my lord, today my representation was to make that jal scheme in my land. From RTI report, I find, my lord, they have been using the others' land. Now, my lord, my previous submission was if you do not find my land, my lord, to be implemented in jal scheme, my lord, you return my land. You cannot take
What
away
is your
land in that.
stand?
My lord, Because, this- my lord, at the time of boarding, my lord, some problem is there.
Very good. It may happen.
That
What is your stand with regard to the return?
return, my lord, at the present position regarding return is concerned, my lord, I'll
That
take
report
an extract.
exactly report.
What report you have stated?
The report is saying that at the point of time, my lord, at the boring time,
No. What is your decision with regard to the return?
return, my
You are
lord.
not. You have taken the land
Yes, my lord.
for the purpose of for a particular purpose.
Particular purpose.
You persuaded the writ petitioner for executing a deed of gift. That has been done.
Yes, my lord.
Now you have abandoned your decision. You are running that project from another land. So what is your stand with regard to the return?
Regarding my lord, return is concerned, my lord, that will take some
That will?
approval for take some approval from secretary, my lord.
No, what report has stated?
Lord, I have been not been able to go.
No, wait. What report has stated?
Page, my lord, 23, my lord. The problem is cropped up at the time of requesting the permission for look for any alternative site for the Kismor Boral PWSS under the Harishchandrapur block 1. This is to inform you that seeking of the big DOLs was completed on 21st November 2023 at the second site. The tube of rig machines cannot be placed again at the hard work seat in Kismot Boral PWS under the Harishchandrapur 1 block due to the sub bands. Boarding of the HW seat is required to be start immediately, otherwise the project is getting delayed. Therefore, requesting to kind permission for look and alternative land at the vicinity of the road to start the project immediately. But that's the problem cropped up at that time of boring, my lord.
What is your prayer?
Lord, my prayer, consider the representation. To consider my representation.
Consider the response to
Yes.
representation annexed at P10. P10 and
P10 at page 71, my lord, of the writ petition.
no, you have not prayed for any return of your land.
No, my lord, at that point in time, we didn't know, my lord, this is the situation. My lord, that's why we pray for, my lord, doing the work in this. Now, my lord, they come up with this report. My lord, saying that
On account of
there are
some technical problem.
difficulty. Now, my lord, kindly sees my lord's last order. My lord, anticipating this and my lord, due to some verbal, my lord, at that point, though I was not there, my lord, I have gone through the order. My lord, where, my lord, prayer was molded to the extent, then return my land. They say, yes, we can return the land. And my lord, report was called for on that account. That is not the, that is on behalf of the power. To submit a report on that account. Today, they cannot cite a technical ground and say that we will hold on to your land and we will also not return your land. Because this is something fraud going on then. Your executive engineer inspected the land. Your executive engineer said the bore can be made into the land. Well, this is something not, my lord, action, my lord, horse has been put before the cart. Rather let them come with a report on that account.
The report
And my lord, page number 23, supposedly, which my learned friend relies upon in the report. My lord, this is much earlier than this submission was made. So, my lord, this submission must be, my lord, on the basis of the information given by the state. State must be having internal communications kept with them.
Very good. Make a representation, I said. They will consider. In the report, there is no such reflection. As otherwise, I
My
could
lord,
have
I am
passed
for
on.
the state respondent, my lord, led by Mr. Asim Kumar Gamu.
এটা কি আছে এটা কারেকশন কেন হ্যাঁ
Yes, my lord, I am for the petitioner, my lord. In this matter, my lord, kindly give me liberty to, my lord, correct.
ম্যাডাম ওয়েট এটা কি আছে
But to correct the cause title of the in cause title with respect to respondent number 5 and respondent number 7, because respondent number 5, the envelope returned with an endorsement that address is shifted. Another is 7, he called me over telephone that this is not the proper address. He has given the proper address.
Liberty is given to the learned
Submersible pump, because it is a temple and the premises is used for the temple, and we are the Sevites, and my lord, it is declared by the civil court. The decree I have annexed, my lord.
then you are representing all the state respondents
Of the
oh
state.
তাহলে ওইটা দরকার নেই
Then my lord, I shall
very good
serve upon him.
no yes he has received that is why he has filed the report
No, my lord,
you are ready with the hearing
my lord, if আপনি এদের হয়ে আপনি করছেন, দেখুন তো এই ঠিকানাগুলো ভুল ছিল বলে আমাকে ইনফর্ম করেছে সুপারিনটেন্ডেন্ট ইঞ্জিনিয়ার। অ্যাকচুয়ালি রেসপন্ডেন্ট নাম্বার 7 is the appropriate authority who has installed that submersible pump.
Lord, executive engineer, I have given the my lord report, my lord.
But he has
Land hand over to the PhD department.
Respondent number 7
7.
superintending engineer
Superintendent
who
engineer.
is the executive engineer
Yes, executive.
no he is representing them
Yes, my lord.
very good
Wait,
বসুন দেখে নিচ্ছি ওই নোটিশের পার্টটা বাদ যাবে what is your prayer
My prayer is, my lord,
it
kindly.
is for to take discussion
I have given
to
the.
take discussion forthwith means
No, my lord. Kindly come. The respondent number 2 to decide the matter, because, my lord, they are saying that.
kindly come to prayer A
Prayer A, my lord, written. The madam was commanding the respondent authority to take decision forthwith on
what is decision
representation. To take decision.
মুশকিলের কথা হলো
Representation, my lord.
উকিল বাবু তো
Not decision.
এটা দাদা উকিল বাবুকে তো
What?
বলুন এটা কি লেখা আছে বানান করে পড়তে বলুন
My lord, that is a printing mistake, my lord. Decision of the representation, my lord. That time usually we are praying, my lord, that it is there.
would you to take discussion so I'm discussing
First of all, my lord, kindly, my lord, come
where is your representation
to the order passed by.
where is your
Honorable Justice.
representation
Last representation, my lord, I am placing it.
Madam, I want to see your representation. If you are not ready, I will adjourn the matter. Don't waste my time.
My lord, page 70 And
70.
P9. The authorities, my lord, forcibly installing the submersible pump over a private Devottar property.
Yes. So according to you,
Yes.
the submersible pump has been
Installed in
installed in your property.
yes, 1262 dak. Main dispute is with 1262 dak. And my lord,
Kindly see page 2, my lord.
I will hear you, sir. Yes, then
my lord, in one writ petition, it has been revealed. My lord, kindly have a look into page 48 of Annexure P4 of the this writ petition.
page number
48. This is the order of Honorable Justice Amrita Sinha, where it has been revealed.
give me a second, sir. Give me.
Yes,
Yes.
yes, my lord. Kindly have a look into the order.
You are the petitioners there.
No, no, no.
Then who are the petitioners?
My lord, one of the co-sharer was petitioner therein.
No. Sri Hori Thakur
On behalf of
represented by such and such.
uh-huh.
So you are also there.
No, my lord, I am not there. We are not there because these petitioners are the separate Sevites. They are Sevites. And Hishikesh Santra is one of the co-sharer.
Then who are you?
I am Sevite. I am recorded Sevite, and that was declared by the civil court, my lord. That order I have annexed.
Very good. Then what happened?
Then happened, my lord, kindly have a look into this order, my lord. Here what said by the government authority. My lord, paragraph 5 of this order, my lord. Interdepartmental and paragraph 6, my lord.
Yes.
Yes, my lord.
So by way of interdepartmental transfer,
My lord,
the PHE authority has obtained the possession of the land.
obtained the possession of
And before
my lord.
the coordinate bench, you failed to produce any document.
No, that is there. That is not there. Ownership.
Point number 5.
Kindly, my lord, kindly have a paragraph 6 as appear from the petitioners that they cannot prove any document of ownership. My lord, if that is recorded in RS, my lord, that is Devosthan. It has not been made. It may not be produced by that person, but it is there, and the decree is there also.
It is pertaining to which plot? Your name is recorded there?
Yes, Devosthan. As Devosthan, it has been recorded.
No. Where?
Yes, I have annexed.
What is that document?
I am showing, my lord. Give me some time. Yes, my lord. Page 39. This is RS record. All of a sudden, my lord, LR is blank. And by taking advantage of that, my lord, this authority...
Wait. Page number 39.
39 of the writ petition.
What is the plot number?
1262.
1262.
1262. Ishwar Mana, Devosthan, Dong, Sadharon, and 1 to 6 where the respondent,
It is RS or LR?
it is RS.
Then what happened at the time of LR recording?
LR, my lord, just next page, my lord, kindly have a look into 40. This is blank. Exact status of the plot was not shown before the coordinate bench. Just next page, my lord, 40.
Then what happened?
Then, my lord, by taking advantage of this blankness, my lord, in a record, my lord, they have the authority has entered.
Where is the order of the appellate authority? Judgment of the appellate court.
There is no appellate court, my lord. This is the order of the.
No. Where is the judgment of the appellate additional district judge or
No, there is
civil
no.
judge senior division? What is
Senior
that
division.
judgment?
Yes, my lord, I am showing. There is a.
What is the degree?
Yes, my lord, degree. That this respondent number 1 to say, kindly have a look into page 65 of my writ petition, my lord. That is ordering portion of the degree that is being annexed.
65.
Yes, my lord. That is only ordering portion, my lord. Entire degree I am not placing, my lord.
That is the part of the last page of the judgment.
Yes.
What is the degree?
Degree is not there, my lord.
So without degree, how can I ascertain what is the schedule of the land? What is the suit property?
Yes, my lord. That may be there.
What is the degree of the trial court?
Schedule of the land was there, my lord. Degree is not there, my lord. It is very old,
And
old case. And
how can I know?
I can produce the print or anything else, my lord. That Parushu Bashutidak was involved in this matter, and my lord, ordering portion, my lord, kindly have a look into. In view of that, responded there. We have recorded a Sebait, my lord, by the appeal court, title appellate court.
Ma'am,
Just-
try to understand what I am saying.
Schedule, my lord. Your lordship is talking about schedule, my lord.
Your suit was dismissed by the trial court.
Yes.
Before the appellate court, you obtained a degree.
Obtained the degree.
The
And
judgment
these
of,
1 to 6 who are
please listen.
Yes.
The judgment of the trial court was set aside. Then the appellate court passed a judgment that you have referred. I want to see the degree of the appellate court wherefrom I will get the schedule. Then how can you rely upon that? In the judgment, the plot number has been mentioned.
Checking it.
কিছুই পড়ে আসেন না চলে এসেছেন
My lord, once my lord respondent is called me over telephone that you have not sent me the improper address. Now they are saying they are engaged the lawyer. What can be done, my lord? আরেকটা নিয়ে দেখো তো মনে আছে। Yes, my lord. Kindly have a look into page 55 of the degree. Writ petition, my lord. Here it has been written that plot number 1262.
Come to page number 51A.
51A. 55 it is there.
Second line.
Yes, my lord.
That is CS plot number.
CS plot 1262, RS 1262, and LR also 1262.
What is your case?
And
What is your case? Sir, what is your case?
Kindly see for a moment, my lord, page 2 of my report, my lord. That is the LR record of right. My lord.
yes.
Clearly recorded, my lord, পশ্চিমবঙ্গ সরকারের পক্ষে collector. Page 2 of my.
No, first page. Place the first page.
Yes, my lord.
That report is not handed over to me, my lord.
Give her a copy.
But only one copy with me, my lord. After making the Xerox, my lord, and hand.
Why?
Surprisingly, that report is not also handed over to us. Not because it is very old matter. Someone just torn copy of the judgment. That is why.
যত গভর্নমেন্ট আছে সব
So where is your document of title?
yes
RS is my.
It shows your,
Now
it may show your position and
Yes,
the
sir.
material.
But my lord, nowadays, my lord, in the present position, my lord, in as per land acquisition and other acts, my lord, RS is being given title nowadays. Nowadays, in RS, if it is RS cannot be changed after 60 years, my lord.
Hmm.
That embargo is there. Therefore, my lord, RS gives title.
আসুন তো ওই কি বলেছিলাম ওই লিবার্টি দিলাম একটা লাইন অ্যাড করে দেবেন তো, অন কনসেন্ট অফ বোথ দি পার্টিস দ্য ইনস্ট্যান্ট ম্যাটার ইজ টেকেন আপ ফর হিয়ারিং। এটা হিয়ারিং বোর্ডে নেই তো আজকে, টুই মেনশন আছে, অন কনসেন্ট অফ বোথ দি পার্টিস দ্য ইনস্ট্যান্ট ম্যাটার ইজ টেকেন আপ ফর হিয়ারিং।
Lord, the contempt petition, Lord, I am the petitioner, Lord, that is appearing for the first time. There is a violation of the my lord's order dated, Lord, Lord, the 21st day of May 2024.
Show me the relevant portion, sir.
Lord, the page,
Paragraph 12 of order.
page 35, paragraph 12 of my lord's order. In view of such, while disposing of the instant writ petition, this court direct the respondent number 4 that the Board of Councillors Southdown the municipality to consider the written notes of argument which is available at page 33 to 37 of the supplementary affidavit as filed by the writ petitioner, as well as the annexure A14 which is available at
Sir,
page.
is it require? Is it in relation to a change of user?
No, Lord, it's not a change of user. Lord, what happened? These are the, Lord, my written objection submitted before the Board of Councillor regarding the unauthorized construction before the approval of the building plan.
আচ্ছা আচ্ছা, আসুন।
And Lord,
On
the
perusal of CPAN 1014, Rodna Saha.
Well, I'm not a physician. This is the first time I read contempt application. Lordship passed this order on page 53.
Page number, sir?
Page 53,
Which paragraph is relevant?
24.
Postgraduate scale.
Fellowship.
আচ্ছা। On perusal of the petition under consideration and नहीं, 678. 678 are identical.
I'm for the petitioner.
Give me a second, Mr. Marna. Yes, Mr. Manna.
My lord, I find that on 2, 3 occasions the petitioner was not served or notice, etc. But here kindly come to page 11, para 9.2.
Yes.
This is kindly I'm reading. Eventually, the petitioners contacted with their advocate, Ms. Manali Biswas, to proceed with the petition. They have found that
Paragraph 9.2.
Yes.
It starts with meanwhile.
Meanwhile, 16421.
16421.
Page 11.
Page 11.
Page 11. Yes.
It starts with meanwhile the petitioners are found. এই উকিল লোকদের রাখো এটা দেখুন ঠিক জায়গা দেখছি কিনা
Well, most of the same. I'm
Your brief differs from my brief.
No, actually, we transfer brief, so I did not got all the papers correctly. However, I'm following that. And see,
I filed one. As per order of the Honorable Court, my lord, I filed the report. That I've seen. Yes, ma'am. And in that report, my lord, everything was there. No, let him face his case. My lord,
my lord, I was the first arbitral award date is October.
So far, my recollection.
October 10, 2017, got it? In the middle of the paragraph, passed by the respondent number 5, the district magistrate and collector, Murshidabad, filed an application under 34 of Arbitration Act and Concession Act, whereby the petitioners had not been made parties. And
the
as
district
such,
district magistrate and collector filed an application whereby the petitioners had not been as such, no notice was served upon it. Then
the London District Judge Murshidabad Intel passed the order. Now come to the last part of the operative part of the order. He was, I am reading, after hearing submission of both sides and after going through the provisions of the concerned acts, I have found that when the arbitration proceeding was taken up, the London District Magistrate Murshidabad at the first sitting on 22/8/2017, and when thereafter he passed the impugned award on 10/10/17, he was no more the statutory arbitrator appointed by the central government, as the central government has already appointed London Divisional Commissioner Malda as a statutory arbitrator under 3G5 of the National Highways Act to deal with the arbitration work relating the land acquisition proceeding for the revenue district of Murshidabad via Gazette notice number so and so of 17.
So the award was set aside.
Here is my grievance. My lord, see, this before the district magistrate, it was arbitrated by in both side presence. Then the authority did not take that they have no authority. When the DM hike the amount on 80,000 per decimal, then I have silently going to the appellate oath before district judge, and then did not serve the copy. And my lord says, the order says that the by notification dated 31st May 2017, the authority has been changed from district magistrate to divisional commissioner. Here lies my grievance, and my lord kindly consider that during the proceedings, I served notice upon the joint secretary asking the copy of notification. Still is unreplied. And it is my belief that unless the notification I do not get, that will not be any effective hearing of the application. But this is the main secret of these proceedings. When the hearing was taken up on 10/10/17, it says that they are notified and changed how the hearing before DM could be conducted by both the parties. They did not raise an objection.
So what is your grievance? I fail to understand.
my lord, grievance is said, firstly, the district magistrate had no authority. The district judge says. But and they referred some notification, I am not aware. But when hearing,
After that, my lord, divisional commissioner passed the award. Yes, my lord. Passed the award.
that also not served any notice.
My lord, if you are
And my lord, my prayer is this,
এই ন্যাশনাল হাইওয়েজ একটা বার করুন কি বলছেন
and my prayer is this.
What is your prayer?
There is this prayer B first time reading. Any further or further read in the nature of mandamus unless we peruse the notification, we cannot come into we can ascertain whether actually the notification was acted upon and why it was not acted on before the district magistrate, why district magistrate took up the hearing.
Go through my I'll see, sir. I'll see. So before the divisional commissioner, you were not party
No,
in the arbitration case.
no.
Then what relief now you want?
I want the relief that fresh arbitration may kindly be direct to be conducted upon furnishing this gazette notification dated.
No. Kala has passed any award in favor of you.
Award was given by district magistrate 1,80,000 rupees per decimal.
That was set aside.
Set aside ex parte without serving notice, and now came down only 29,815 per decimal.
In a miss case under the Arbitration Conciliation Act, the district judge has held that at that material time the district magistrate was not the arbitrator.
Yes.
Set aside the award passed by the error.
Yes.
Directed the matter to place before the appropriate arbitrator, that is the divisional commissioner.
Yes.
Have you approached?
Notice not served, but after passing the order, we somehow
you have to approach. Who will serve notice?
This divisional commissioner.
Please?
The now says the authority is the divisional commissioner. Who is the here? This one number.
Subsection, read subsection 5.
This one 7 here.
Read subsection 5. Am I correct?
Subsection
5.
3G, 3F.
Place, sir, place. Mr. Manna, kindly read loudly, sir. 3G5.
3G5.
Yes.
3G5.
Your right hand side.
Oh, yes, 3G5. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties.
To either of the party.
Yes.
So you are to approach.
The amount set on application by other parties to be determined by the arbitrator to be appointed by the central government.
So you have to approach before the divisional commissioner.
My lord, what that is in the report, my lord.
He made, also made an application.
Page 2, admit that. Page 2, my lord. Report page 2.
I'm on that, sir.
Yes, my lord, only for that reason. As he.
Their name is not transparent.
No. As they never applied for that reason, my lord, we have considered his case also. The instant applicants of this case were not the applicants in the arbitration case. But in compliance of the order of the arbitrator, the Kala has allowed arbitral compensation to all the awardees of the LA case. The instant petitioner received payment notices but did not turn up to receive the payment.
That is 421, your first reading.
Oh, they have received the award.
No.
No, my lord. He was asked to receive, my lord. He
was
denied.
asked to receive, but he did not turn
So
up.
award was by the award, the amount of compensation was revised.
That is dispute in settling the amount because they estimated.
My lord, their only contention in lordship, the amount is now lesser than the previous one. That is their
Not
contention,
only
my
that,
lord. How
but
lordship, the
only
writ
that
court
the-
will decide.
Challenge the award in
My
the
lord.
appropriate proceeding.
My lord, that well, yes, my lord.
Challenge the award in the appropriate proceeding under the
My
Arbitration
lord.
Consideration Act.
My lord.
Pass that order in the judgment, my lord.
No. If any award is not correct, then provision is section 34 is there.
Yes, my lord. See, my lord. Prayer see.
Yes,
my lord.
Direct them to furnish the copy of this gazette notification kindly. This is the main crux.
No,
point.
that I will not.
Is it notification available in the
Ashok.
newspaper? The public domain.
Public domain.
This court has 34 proceeding,
64 proceedings.
no liberty,
Should it mean dismissed or disposed?
dismissed. এটা কোনটা?
I'm getting.
Challenging the award 34 will lie, and against 34 you have to file an appeal under section 36, 37.
3 months from the date of communication of the award.
Yes, yes.
There's no limitation. There's no application of limitation act. Beyond time cannot be.
Who is for the petitioner?
9, I am for the state one.
You are for the petitioner. What is your grievance?
রিপোর্টটা কনসিডার করো। ঠিক আছে না?
Petitioner is the absolute owner of the land administering 2 shatak in HAL plot number 1202.
Sorry?
In HAL plot number 1202.
Huh.
In Mota Dhaniagiri, Police Station Jaipur, Block Amta 2, District Howrah. And respondent authority has utilized the land of the petitioner.
In earlier occasion, your lordship heard this matter, your lordship directed to consider the representation. Annexure P4. That my lord, that is on কত ছিল ওটা? 23rd. 23rd, your lordship heard, but not
It is there
even in the server copy.
Order is not
Not in the
uploaded.
server copy.
Server, it has not been.
Not been given. Number to pull out. This was directed to consider the representation. Annexure P4.
Have you made the BLRO party?
It was directed the district magistrate to
District
consider.
magistrate. Respondent number
আচ্ছা, দুপুর আছে এখানে দেখো।
The
গৌরব আর গৌরব দাস।
Number 10.
I am appealing for the petition, HON'BLE.
Lordship, Mr. Galib is appearing in this matter, Lordship.
Yes.
Madam, I'm waiting for the item number 11 and 12 led by Mr. Shomitra Mandra. Similar matter, madam.
10, 11, 12 are identical.
Yes, ma'am.
In 10, Mr. Galib is appearing in this matter, Lordship, in item number 10.
And 11 and 12, Mr. Shomitra Mandra is late. Appearing matter.
You have filed a report.
Lordship, I don't have the report because Lordship, Mr. Galib is appearing and his matter is going on in court number 26.
I have the report, my lord. In item number 11 and 12, I have the report.
11 টা দেখি আগে।
Item number 11 and 12, both I have report, my lord.
Yes, place your case.
Well, I have challenged the order, my lord, at page 56, my lord, of the writ petition.
56.
Yes. And particularly,
56 is the order of a coordinate bench.
my lord, item number
27702 of 2024.
Oh.
The name of the writ petitioner is Asar Pradeep Brickfield, represented by Anup Kumar Samanto.
Oh, yes, my lord.
27702. Take that file.
At page 52, my lord.
52.
Yes. Particularly,
Give me a sec. Give me a second, sir. Page number 52. What is that? Order dated 2/2/2024.
yes, ma'am.
Yes, sir.
Royalty claimed on the basis of a second para on the backdrop.
Place.
Yes. On the backdrop of the above factual matrix, the matter is placed under the scanner of the provisions at
You are reading from which portion? Page number 52.
53, ma'am.
53. I see.
Paragraph number
This is the main. Yes,
I see. Very good, sir. I got it.
yes, ma'am. Second para. On the backdrop of the above factual
So
matrix.
factual matrix is required to be looked into.
Yes.
Place from page number 52.
52.
Place from page number 52.
Yes.
I'm not aware of the factual matrix, no?
Sorry, ma'am. The matter is for final hearing and order. Anup Kumar Samanto remains present on behalf of Messrs. Asar Pradeep Brickfield, heard at length, perused the documents submitted by the petitioner. The petitioner has also submitted a written note which is made a part of the proceedings.
Yes.
In a nutshell, the crux of the matter is stated hereunder. Messrs. Asar Pradeep Brickfield and Company under the brand and style Sri Brick is located at Bauja, Mathuri, jail number 79, PS Tomluk district, Purbo Midnapur, and it has been running the business since 2017. It is pertinent to mention that Brickfield was set up by virtue of registered lease deed.
being number 2153 dated 34/2000. That is, my lord, lease deed means with the private owners. And later on, for extension of the manufacturing unit further, an unregistered lease deed has been executed. The said Brickfield had also obtained the pollution certificate and got consent to operate certificate from appropriate authority for the period of 5 years, that is 2018 to 2023. So now the Brickfield is running its operation without consent to operate certificate since 2022. So the Brickfield is duty bound to pay royalty and cess for the period 2010 to 2023 and piece of earth for the financial year 2023 to 24. The management of the Brickfield contended that as the land used by the Brickfield is a private land, the state cannot demand an royalty and cess.
Oh, it is that matter.
Yes, madam.
One judgment was placed before this court. Mr. Galib submitted before this court that he will come with after perusal of that judgment. Where is he?
Lordship, in court number 26, the matter is going on, Lordship.
No, তাহলে এটা হবে না এখন। Last day of August, not today.
My lord, before my lord, this order may be corrected. Item number 11 and 12, my lord. And order.
Is there any wrong printing? What correction is required, sir?
Yes, my lord, I'm sorry. Item 11, which is, my lord, demand notice dated 26/9/24, which is, my lord, annexed at page 55.
It is not 2022-10.
Yes, 26/9/2002.
Page number?
Page number 55.
Huh? 55.
2024.
Asar Poti, my lord. Asar
26/9. Oh. Ashut.
I mean item 10, Lordship.
তাহলে ওইটা করো না, জানো 11টা ওই পোর্শনটা করো না, টাইমটা চাইও না, কারেকশন গুলো হলো। ভেরি গুড।
And item 10. That is the, my lord, commission, the royalty was assessed on the ground of section 4, subsection 2 of clause A.
Give me a second, sir. Yes, you are placing the orders.
Yes.
Place the order.
Now, at page 53, my lord.
No, Mr. Galib is appearing in 10.
I mean 10, Lordship.
Then come to 10.
First, at page 52.
56.
27690.
Page number 56. Two seven six nine zero. Take the file of 27690.
Your Lordship had an order also, already parts one order in this matter. On 23rd June, kindly have a look, my lord. My learned friend relied upon two judgments.
Please help your senior to find out the right file.
27690.
27690. New Ma Bongolokhi Brick Industries Company versus the state of West Bengal and others.
And now at page 56. The matter, order dated 2nd February 2024. The matter is put up for final hearing and order. Shrikant Samanto remains present on behalf of New Mahabagolamukhi Brick Industries and Company. Heard at length, perused the documents submitted by the petitioner. The petitioner has also submitted a written note which is made a part of the proceedings. In a nutshell, the crux of the matter is stated hereunder. New Mahabagolamukhi Brick Industries and Company under the brand and style Shri Brick is located at Mauja Uttar Chhara, Shankarara, jail number 142, PS Tomluk, district Purbo Medinipur, and it has been running the business since 2017. It is pertinent to mention that Brickfield was set up by virtue of registered lease deed, being number 5306 dated 9th September 2015, and later on for extension of the manufacturing unit for the registered deed being number 1268 dated 19th March 2020 has been executed. The said Brickfield has also obtained the pollution certificate and got consent to operate certificate from appropriate authority for the period of 5 years, that is 2017 to 2022. So now the Brickfield is running its operation without consent to operate certificate since 2022. So the Brickfield is duty bound to pay royalty and cess for the period 2017 to 18, 2018 to 19, 2020 19 to 20, 2020 to 2021, and 2021 to 22, and price of earth for the financial year 2022 to 23 and 2023 to 24. The management of the Brickfield contended as the land used by the Brickfield is a private land, the state cannot demand the royalty and cess from the Brickfield owner. The Brickfield management in the same fashion did not deposit the royalty and cess or price of earth since 2018 to 19, and huge sum of money amounting 20 lakhs 21,126 is due for payment before the government of West Bengal. The Brickfield owners moved before the Honorable High Court at Calcutta by filing WPA number 1261 of 2023 for consideration of the writ petition which is pending before the concerned authority, and the Honorable High Court has been pleased to pass an order 24/7/23 directing the ADM and DLN and LRO Purbo Medinipur to consider and dispose the comprehensive representation if filed by the writ petitioner by passing a 57, Malad, repeat. On the second, on the backdrop of the above factual matrix, the matter is placed under the scanner of the provisions as envisaged in the existing statute. On plain reading of subsection 2A of section 4, it appears no riot shall clause A query sand or permit any person to query sand from his plot or land, or clause B dig or use or permit any person to dig or use earth or clay of his plot of or land for the manufacture of bricks or tiles. Second, Roman 2 para. So no person has any subsoil right, even if the right can't dig or excavate or manufacturing the bricks or otherwise. Third, it is well settled that the state government has the power to make rules in respect of minor minerals in consonance with section 15 of the Mines and Minerals Development and Regulation Act 1957. Fourth, in exercise of power conferred by clause G of subsection 1A of section 15 of Mines and Minerals Development Regulation Act 1957, read with sub-rule 1, Rule 35 of West Bengal Minerals Concession Rules. The government of West Bengal prescribes the rate of royalty and says by notification number such and such, dated 3rd January 2022. Under the circumstances, the management of the brickfield has failed to deposit the outstanding dues at the tune of rupees 20 lakhs 21,226 for the that is the assessment. So this related the case is disposed of and the order dated 24/7/2023 in connection with WPA number 1261 of 2023 in the matter of Numa Bagalamukhi Brick Industries and Company versus the state of West Bengal and others is complied.
So payment of royalty and cess for manufacturing bricks
Yes.
does not depend upon the ownership of the land.
Done.
Subsoil right always paramount right of the state. On consideration of the above, the representation is rejected. You are directed to pay such and such. Now you have placed some judgment.
Yes, Malad.
Where a single bench of this court held that as a particular section is ultra virus.
Ultra virus.
Place that.
AIR
4-2A.
AIR 1975 এখানে আছে
দেওয়া আছে ফাইলটা এখানে দেওয়া আছে ও আছে আছে ইজ দেয়ার AIR 1975, yes.
Paragraph 26. Paragraph 26, particular. The section 4, 2A, clause B, so far as
paragraph 26.
Yes.
Four 2A. Yes.
Paragraph 26, my lord. The section 4, 2A, clause B, so far as it prohibits a riot from excavating or using either himself or through others earth or clay for brick making, it may be said to be ancillary to the provisions of subsection 1 and 2 of section 4, which defines the extent of the rights of a riot qua owner of his holding. But the state legislature, by empowering the rule-making body to prescribe the terms and conditions for grant of permission to excavate for use of earth or clay in brick making, clearly exceeded its legislative competence. After the declaration of the central government under section 2 of the Mines and Minerals Regulations and Development Act 1957, the entire field relating to mines and minerals came to be occupied by the parliament. The state government, only as a delegated authority, has been empowered to prescribe rules relating to minor minerals, but the state legislature is no longer capable of enacting a law of its own relating to minor minerals. Then second, 27 paragraph. Therefore, the observations of the Supreme Court in AI
Just a minute, sir. But the state legislature is no longer capable of enacting a law relating to minor minerals. Now the law has been taken into come into force. West Bengal Minor Minerals Act is there.
2016 concession rules.
ये देखिए, हाँ. West Bengal Minor Mineral Concession Rules is there.
But
anyway, please.
27. Therefore, the observations of the Supreme Court in AIR 1970 Supreme Court 1436 Supra regarding absence of legislative competence on the part of the Bihar legislatures to amend the Bihar Land Reforms Act by adding second proviso to subsection 2 of section 10 of the Bihar Land Reforms Act are equally applicable to the instant case. Different parts of section 4(2)(a) clause B are not severable. Therefore, although the state legislature might have been competent to provide that a riot who has no right in the subsoil of his holding shall not be entitled to excavate or dig earth, it could not have been provided for terms and conditions for granting of permission for excavation and user of brick earth by riots. Therefore, section 4(2)(a) clause B must be struck down as ultra vires.
So, will you place paragraph 27 once more? Paragraph 27.
Therefore, the observations of the Supreme Court in AIR 1970 Supreme Court, page 1436 Supra, regarding absence of legislative competence on the part of the Bihar legislature to amend the Bihar Land Reforms Act by adding second proviso to subsection 2 of section 10 of the Bihar Land Reforms Act are equally applicable to the instant case. Different parts of section 4(2)(a) clause B are not severable. Therefore, although the state legislature might have been competent to provide that a riot who has no right in the subsoil of his holding shall not be entitled to excavate or dig earth, it could not have provided for terms and conditions for granting of permission for excavation and user of brick earth by riots. Therefore, section 4(2)(a) B clause B must be struck down as ultra vires. That is the section 15 of the Mines and Minerals Act 1957. The state can make a rule, but in this connection, only two rules means he can edit the requirement of the quarry lease and to make a not having and terms and conditions, but it was excluded from this section of 4.
Sorry?
But the central government, under the central government, the Mines and Minerals Act Regulation 1957, section 15, the state government can make a rule. But what is the requirement? Rule is means, I am showing the one judgment particularly. For AIR 1986, there clearly stated.
লিখে দাও পিটিশন আর বলে নাহলে বুঝতে পারবো না।
Particular, my lord, that at page 15, my lord, paragraph 43.
Para
43. To appreciate the controversy raised under this head, it is necessary to keep in view of the power which has been delegated to the state government under the statute. Under section 15 of the said act, the state government has been empowered only to make rules for the grant of quarry lease, mining lease, or other mineral concession in respect of minor minerals and for the purposes connected therewith. So, there is no rule to grant the quarry.
Under section 15 of the said act means which act?
Mines and Minerals of and Regulation Mines,
have you brought that act?
at the heading, my lord.
No, no, have you brought that act?
57 Minor Minerals Act is, my lord, is a part of that particular concession rules, my lord. It is in that book itself, 57 Act. Lordship kindly sees.
Yes, 1957 Act is there.
Starts with that, Lordship.
Section 57.
Lordship. It's an act of 1957. My learned friend is relying upon কোন section I'd like question.
15.
15 or rule making power of the state, Lordship.
1515.
Lordship.
Yes, then.
So in this, my lord, section 4, it was excluded for the grant of quarry lease, mining lease, or other mineral concession in respect of minor minerals and the purpose of.
No, 15(1)(a)(g), in particular, without prejudice to the general of the such rules may provide for all or any of the following matters, namely the fixing and collection of rent, royalty, fees, deed rent, fines, or other charges, and the time within which the manner in which these shall be applicable, payable. So that has been done.
But this was not included in this section 4 of the West Bengal Land Reforms Act.
No, sir.
That ground, my lord, ultra varies. Declared ultra varies. But in this section only stated section 4, my lord.
When the rules have come into force.
But this order was passed following under section 4(2)(a) of the West Bengal Land Reforms Act.
It was notified on 29 July 2016.
But order was passed following, my lord, section 4 of the West Bengal.
This judgment was dated.
Section 4(a) of the Land Reforms Act, my lord.
Yes, what is your contention?
Yes, so no such rule was made that if the land is dig or use or permit any person dig or use or earth or clay for his holding for the manufacture of bricks or tiles, no such rule was made that it is required to grant the quarry lease and mining lease or other mineral concession in respect of minor minerals. That is relying on the paragraph 43. The paragraph 43 of the reference judgment. AIR 1986, Calcutta 1. So no rule was made for the requirement of query lease or.
On Assam 50 the state government has been empowered only to make rules for grant of quarry, mining lease or other minerals in respect of the then
In respect of minor minerals and for purpose connected there. But on that issue, no rule was made.
Which issue?
To query lease, the grant of query lease and mining lease.
This rule is for what? Minor mineral concession rules?
The submission of the learned settlement on the West Bengal
minor mineral concession.
West Bengal minor minerals and concession rule 2016. But there is no such rule that it is requirement to query grant the query lease or mining lease or other mineral concession in respect of minor minerals. That is means clause B of section 4(2)(a), dig or use or permit any person to dig or use earth or clay of his holding for the manufacture of bricks or tiles. On that issue, no such rule was made. It was excluded, this rule. Even the order was passed following the Malot.
Fixing and collection of rent, royalty, fees, deed rent, fines or charges. So, in respect of G, no rules have been made.
No rules is made that it requires to the grant of quarry lease. If the land is for the purpose of manufacturing the bricks on the
what I
private
intend
land.
to know, so far as section 15G is concerned, that says fixing and collection of rent, royalty, fees, deed rent, fines or other charges, and the time within which to that extent no rules have been framed.
No. First of all, it will be made to query lease. Then come to the conclusion point that it is required to payment the royalty.
Such rules may provide all or any of the following matters.
Kindly at present, paragraph 60, explanation of the reference judgment. AIR 1986, Calcutta High Court, page. Yeah. Now I am submitted all in AIR 1986.
Yes, I got it. Paragraph
60.
60.
Yes, madam, 60. Demand for royalty. Under some of the notices improved in these proceedings, the authorities concerned have demanded payment of royalty from the petitioners concerned, who are alleged to have extracted or disposed of or consumed bricks, earth, without any quarry permit or other lawful authority. On a consideration of the relevant provisions of the said Act and the said rules, it appears to me that the prescribed royalty or minor minerals can only be demanded by the state in case where a valid mining lease or a quarry permit has been granted by it and under the said concession. Neither the Act nor the rules, in my view, envisage collections of royalty where the mining operation resulting in extraction and disposal of minor mineral is wholly unauthorized. In such cases, the claim of the state, it seems, should remain confined to the mineral unlawfully raised and their price. This is clearly established by section 15(3) of the said Act. Then 61. When he can claim royalty, section 21(5) of the said Act, relied on by the respondent, in my view, does not add the case of the state government, as in none of the notices involved, it has been alleged that the petitioners were in unlawful occupations of land. That is means, in fact, all the cases the petitioner have claimed some title to the land which has not been denied or disputed. There is no disputed that is the private land. In any event, there has been no fixation or determination of rent or royalty or
Says the demand of royalty presupposes a valid mining lease. So you have valid mining lease.
No, there is no no money. That is why the representation was made. As per order of the Honorable, representation was made to treat the privity contract between the petitioner and the state authority. That is means lease. But this was rejected. The representation was made. Representation, as per order of the Honorable Court, page 17, my lord, of the writ petition.
Page
70.
70.
17, my lord, 17. And particular para relay 2 and 3 at page 18. I'm submitting. I submit to you paragraph 2. Page 18. I submit to you that the lands in questions of the applicants relating to documents as per C, Annexure C collectively stood not vested land in the state. The land had silted through.
Page number 17.
Page 18, madam. 17, madam, representation.
Sometimes you are saying 17, sometimes you are 18.
No, 17 is a starting word. Representation.
Yes.
And now I am submitting at page 18. Paragraph 2. I submit to you that the lands in questions of the applicant relating to document Annexure C collectively stood not vested land in the state. The lands had silted through creek of Mauja, Uttarchara Sankarara from the river Rupnaran, all like deposited by river flood. Such land situated beyond the foreshore of river Rupnaran, whereby also obtained a regular deposit of silt from the river water, and the applicant as leased under the private owners had to silt from alluvial soil. So obtained a regular deposit of silt from the river water to the subject land, which may not be treated as ordinary clay. It is admitted fact there was no dam to obstruct from depositing river.
Then whose land it is? It is whose land?
This is the private land. I have also stated not vested in the state.
Private land means a Rayati land?
Yes, Rayati land. And paragraph 3, my lord, I am submitting. I may be exempted from the imposition of royalty as claim demanded by the block land and reforms officer, Tamluk 1, Purbo Mindapur, notice dated 15 June 2022 and 12 December 2022 as per annexure be collectively herein for the purpose of production of brick under West Bengal Minor Rules 2022 and Mines and Mineral Regulation Act 1957 and allowed to privity contract under you to run the said business in the name of Numa Bakalamukhi Brick
So
Industry.
if the land is a Rayati land, it stands in whose name?
Private person
Is not, it does not stand,
under the state. It is not the.
you are not the owner.
Now, I have also some plot of land.
Yeah, I fail to understand what is submitting. What we have stated in paragraph 2. I submit to you that the lands in question of the applicant relating to document as per annexure C collectively stood not vested land in the state. Very good. The lands had silted through creek of Mauja such and such from the river Rupnana like deposited by river floods. Such lands situated beyond the foreshore of river Rupnana whereby also obtained a regular deposit of silt river water and the applicant as lease under the private. Then if you are there on the owner, then you are why is that question of deed of lease is arising?
That is the at page 32.
You fail to understand what is submitting.
That is the private land. I have annexed the deed also.
Mr. Galib, can you help? I cannot understand.
Since the petition.
Lord says that is a Rayati land, again says is a lessee.
No,
He
lessee
is
under-
saying
it is
that
the private.
he is a lazy of somebody else.
Private person.
He means to say it's a Rayati land and he is a lazy of that particular Rayat. Is it right? And he says that the sealed comes from the river
Yes.
to that land. That is not my fault. It comes to my land from your river. So I am making brick. So this cannot be regarded as ordinary clay. So why shall you charge royalty and cess from me? This is the story. I am the lazy of a Rayati land. That land is adjoining Rupnaran river.
That I have understood.
Sealed comes to that land.
But
I
there is
preserve
a-
it. I
but there is a-
preserve it. I make brick. I manufacture brick. So how can I prevent the river from sending silt to my land? For that, you cannot, the government, you cannot charge royalty or cess from me. This is what the story is all about. Crux. That is the crux. So point number 1 is it's a Rayati land. Writ petition is the lazy of the land. Point number 3, it is adjoining the Rupnaran river. Point number 4, sealed from the river comes to this particular land. From that, point number 5, I manufacture brick. For that, government imposes royalty. Point number 7, he says, I will not. Why? It's my Rayati land. It's not an ordinary clay. So I'm not bound to pay the royalty or cess. Right, sir? So, my issue is.
In
Achha,
that
it's
case,
not-
I'm filing the Supreme Court judgment, Honorable Supreme Court judgment. I have my lord.
Sir, unless you place the facts properly, how can I assess the judgments?
No,
There is a
since-
difficulty. Okay, come on.
Yeah, since no rule was made to grant requirement of lease. So he cannot.
Mr. Gali, you have submitted report.
No, it's our recent order is under challenge. So that is our stand.
But this order was.
Our recent order.
Following under section 4 of the Land Reforms Act.
So I shall justify. I shall.
Rules.
All right, I shall
This
justify.
order was not passed on the West Bengal Minors and Minerals 2016. Order was passed following under section 4 of the Land Reforms Act.
Not only that, that is not the only sole section relied upon. And what was declared ultra vires, I shall show your lordship. What was declared ultra vires by the Honorable Single Judge, I shall show your lordship. Let my learned friend complete. It key.
Yes, sir.
Supply.
And then my Honorable Supreme Court.
For supply.
1993.
No, so far as AIR 97/575 Calcutta is concerned, you say that section 4 to AB it has been declared ultra vires. Very good.
This order was passed following section 4.
Then what is your contention in regard to year 1986?
1980. That is also following the ultra vires judgment.
Then what judgment you are relying now?
Now, my lord, since this is the manufactured the bridge from the private land, I am relying, my lord, the judgment of the Honorable Supreme Court, 1993 supplementary 3 Supreme Court cases, case 2, and my lord, paragraph 2, my lord. Para 2.
2.
Yeah. Lordship, without wasting time, my lord, since it is pure question of law is there, may I suggest your lordship that the state should come with a short affidavit in opposition on this?
It's better. It is better.
Lordship. Lordship, kindly direct, my lord. We shall come with a short affidavit in opposition, my lord. Representation is not. Presentation is, lordship is having some problem with the presentation.
The order was first following section 4, 2A, so already declared ultra vires, but not order was first following the West Bengal mineral rules.
Same order, same date.
Lordship.
এই রিপোর্টটা ফেরত দিয়ে দিন, উকিল যে রিপোর্টটা দিয়েছেন ওটা ফেরত দিন।
Adjournment.
Time for the petition in this matter.
No, I am for the.
Your lordship last occasion, your lordship had this matter on last occasion and directed my lord to file a report. But I am for the state. Kindly see your lordship last occasion.
I'll narrate the story, my lord. What has happened? First,
directed the state to file report, my lord.
And also
Have
to
an advance copy to us.
also to municipality. Kindly see the
We have got received copy of the report.
Conduct of the petition.
No copy was served. Your lordship
Serve a copy.
Your lordship specifically mentioned to serve a copy in advance.
Why have not served copy?
I'll kindly, my lord, have a look to the report once.
No, unless they have gone through the report, why do I do?
Unless they have, my lord.
My lord has seen on the last occasion about the vesting of the land. This writ petition talks about, he alleges in the writ petition, this is a royalty land. All of a sudden, my name was up in the record of rights. All of a sudden, this government's name has come. So kindly provide me the compensation as per 2013 Act.
Yes.
That is the writ petition all about.
Submit a report.
Now, my lord,
who are you, Mr. Dhar?
My lord, I am for the municipality. My lord, it's this particular land has been. Well, I'm sorry, my lord, I am for the executive officer.
Your lordship has heard this contest on last occasion, and on the perusal of that document, your lordship directed them to file a report and served a copy to in advance. No, my lord, I am appearing on behalf of the. That is the contest on last occasion also there.
chairperson, my lord.
বলতেই দেবে না।
And my lord,
land is vested land, my lord. Thereafter,
my lord, your lordship directed to file
If you go on submitting all at a time, how can I understand?
Yes.
এক এক করে একজন করে বলি।
ঠিক আছে।
No, my lord, kindly come to that.
Sir, I am fixing a date, you serve a copy on that day.
My lord, I make a one submission, my lord.
This is the report of whom?
my state.
My lord, we are not giving any report because state has covered the entirety.
I have handed over the copy of the report, my lord.
Municipality is not filing any report.
You are the municipality, no?
My lord,
Mr. Dhar.
yes.
I
My lord,
am
for
municipality, my lord, chairperson, and he is executive officer. Of that-
more or less our stand would be same.
Same.
Now, my lord, kindly have
You are
the
Mr. Sinha.
Yes.
yes.
My lord, my humble
Era
submission to your
just.
lordship, when, my lord, they have no right to file this writ petition, my lord, writ petition is how the writ petition is entertained.
That was
My
the
lord,
last
they have
conclusion.
no right. They have no right at all. They have no enforceable right to seek any mandamus.
On behalf of
With my lord's kind indulgence, my lord, next item number 15, my lord. My lord, I have 14. My lord, item 15, my lord, I am having some difficulty, personal difficulty tomorrow, my lord. If my lord kindly takes it up some other day, my lord. And for the respondent. My lord, my lord.
Kindly take it on Monday, my lord. I am not a private respondent.
Item 15.
I will
My lord, I have requested for a copy of the petition from the petitioner. My lord, will take it from, because the copy has not. I'm paying for the respondents, my lord. Deeply obliged, my lord.
Your Lordship, item
Deeply
number
obliged.
20, I am for the state. There was a direction
15
to
again?
file a affidavit in report in form of affidavit, but the report is not ready, Your Lordship. Kindly, Your
appearance of
Other side.
not this week.
My lord,
Grateful.
my lord.
At the cost of being reprimanded, Millard, may I mention one matter? It's a very humble prayer. No, I know, Millard, but this is with regard to an original side matter, Millard. It's a very innocuous thing, Millard. I understand, Millard, but if Millard only considers, Millard, there is an order that passed by Millard, whereby Millard has dictated that the matter will be appearing in the list on 4th of July under the heading 48. Now, on 1st of July, there is a list published of Millards for the 4th of July where this matter is not appearing, Millard. That is the only thing I am concerned about. WPO 624 of 2008. On 4th of July. And yesterday the list was published. This matter is not appearing on the list. Yes, madam. This Friday. In the list, this is not appearing. The list has been published on yesterday. Yes, madam. হ্যাঁ, 3 তারিখে বের হবে, তার আগে অলরেডি বেরিয়ে গেছে।
यहाँ से ये ছেলে
Madam, I'm for the state for the circuit bench matter, madam.
You are appearing on behalf of whom?
Madam, for Malad is taking circuit bench matter.
Yes.
Madam, I'm for the state, madam.
Who is for the writ petitioner then? I have not heard her. A
The
lady.
writ petitioner is not appearing, madam. Since last Thursday, no one is appearing for the petitioner, madam.
One lady advocate was there, no?
Initially, Mr. Devosridhar appeared, but he says that he has retired from the brief,
No.
from the case.
His name is appearing on the screen.
Very good. Yes, Mr. Mujumdar.
Lord, I will take only 5 minutes of your lordship's time.
Yes, sir.
Not the.
Madam, my name may be recorded for the state, madam.
Give you a slip.
The chat box is disabled.
এই ওটা দিয়ে দাও, নামগুলো নিয়ে নিও। কে আছেন? এটা নিয়ে নাও, উকিল বাবুর নাম, এটাতে ওই স্টেট অ্যাডভোকেটের লয়ার নাম নিয়ে নাও। Yes, Mr. Mujumdar.
Counter the argument that the writ applications were filed after
You stopped yesterday that no review of judgment of division bench is permissible in this writ petition. There you stopped.
Only 3 points I formulate. First argument was writ applications were filed after the process was finalized or after the examination was held and the list was prepared. Now, WPA 21918 of 2024 was filed before that. So the writ petition
How after holding written examination?
Before the 2024 examination.
WPA number
21918 of 2024.
Yes.
That so far as the opposition and reply are concerned, not the stand of the commission is concerned before the Honorable Division Bench, I have indicated yesterday, which is 148 to 151 of the opposition, and at page 156 of the opposition. Second note, the observation failed from your lordship as to the, I should address your lordship on the point of ratio decidental, their submission. But what is the ratio? But it has a precedential value insofar as settling a question of law. Not the all judgments cited at the bar on the principle of ratio decidendi will have no manner of application in this case, because it's a question of an order binding the commission. There may be a direction without a ratio. Say, for example, there may be a direction without a ratio. Inter say the parties, the order is binding. Commission cannot take now the stand that very well, it has not decided a question of law, therefore I will not be governed by that order. This will lead to judicial anarchy.
Yes.
Number in the preliminary examination held in 2010, there were 3 sessions, same question paper with orientation differently laid, as it happens in every other examination nowadays. The question said, the orientation of the questions will be changed in every session. Same set of 100 questions will be there, but say 1 to 30, what is 1 to 30 in first session, maybe 10 to 20 in the second session.
No, they said that it was on 3 different set of papers.
Different set of papers. Maybe. But that does not change the situation.
Be there as it may, we are not on that.
But so far as the judgments are concerned, I have indicated, I have prepared a note, if your lordship accepts, how the judgments are distinguishable. Instead of reading every judgment, this may curtail your lordship's time. Just 1 or 2 sentences. Now this is in the form of list of dates. The second page goes on to indicate the page numbers in the affidavit in opposition vis-a-vis the stand taken by the commission before the Honorable Division Bench. The third page is the observation of the Honorable Division Bench. Fourth is my submission, whatever I have submitted before your lordship as to why this will not be deviated from and what will be the effect of such deviation. And fifth note is dealing with the case laws. It had to be in my lord. These are my
এটা লিখে রাখুন, উপরে লিখে রাখুন এখানে মিস্টার এস সৌম্য মজুমদার, WPA 2198 what online এটা সারা জীবনের জন্য প্রিজার্ভ করে নেন, সেই জন্য মিস্টার ভট্টাচার্য ওটা লিখে রাখুন মিস্টার সৌম্য মজুমদার, আর WPA 21918 of 2024, WPA 24588 আর 2543. Total 11 matters or 12 matters, including Jalpaiguri matters.
12 matters.
হ্যাঁ, ওটা তো ট্যাগড হয়েছে তো। ম্যাডাম তোমার স্ট্যান্ড নেবে আমার স্ট্যান্ড নেবে হাসি দিয়েছ মেন হাসি আর ডবল ওপি আর আর ইউপি আর ডবল ওপি
Can't be without an emphasis.
No emphasis. Sir, Mr. Bhattacharya, you are appearing in WPA kindly now.
And I am appearing
The
for
one of you should be Dirghu in
WPA?
no, I am Jayanto Sardar.
Kindly tell me the number, sir.
26090. 26090.
Of 2024.
Fine.
Yes, sir.
have lots of sleep.
Yes, sir.
My only short submission to your lordship in reply. Whatever I have gathered from the notes not furnished to me, the submissions furnished, the answer is not there as to what prompted them to initiate a fresh process by way of the fresh selection or written test. The endeavor to conduct written test, why it was done is not explained. I do not propose to multiply anything to whatever Mr. Majumdar has submitted. Lord, I only hasten to add that they understood the purport of the order in their own way. That would find reflection from the documents appended to the writ petition itself. Which documents, my lord? Page 49. Page 50.
Comprehensive affidavit.
In the writ petition. These are referred to in the writ petition.
Your writ petition?
Yes. Page 26090.
Page number?
49.
Then,
my lord, is page 50.
What have you got to say?
Now, my lord, in these two documents, up to page 53, the answer is very clear that in terms of the division bench's judgment, no written examination, nothing. Whatever was there, we will complete the process. The language used need not trouble your lordship, my lord. Language used in the document is has planned to complete the recruitment process in terms of the division bench's order. So if that was the understanding, then nothing.
Very good. I understand your content, sir.
Nothing prompted them to issue page 55, dated 5th August 2024. Now, my lord, as my learned senior, my lord, Mr. Majumdar pointed out, ratio, my lord, subject to correction, the ratio of a judgment is, my lord, whatever he has explained in addition, just, my lord, only one sentence. What can be logically deduced therefrom from the reading of the judgment? The reading of the judgment, the teeth of the judgment, very clearly says that one is debarred in law from filing an application. Paragraph 17, your lordship has read it innumerable times. The endeavor to hold afresh, we would have proceeded to reject this, but considering the plight of who have participated, their fate, we feel that the authorities must act strictly in terms of the order passed by the single bench. As affirmed by the division bench, we are unable to comprehend the stand of the applicant. The further written test is required. That was expressly rejected, not implied. It is not an implied observation or implied conclusion. If a point which is raised, if an issue which is raised is expressly rejected, the authorities are debarred in law to proceed in a manner which is in complete deviation to the conclusion reached by the Honorable Division Bench.
Very good, sir. I understand.
So, my lord, therefore, the ratio is here, no written test, complete the process as affirmed by the division bench. This is where, in an application, this is the 20th application taken out by them. Can 20, not can 1. Extension, ultimately can 20.
No.
Whatever. Very well. This is on in can 20.
Unsuccessful candidate can 20.
Now,
scoreboard does not say the correct figure sometimes.
Now, my lord, please see.
Can 20 does not implicate the 20 applications.
Very well. It was numbered as can 20. Very well, 3 applications. Well, I take it, my lord, I was wrong. But the fact remains, in can 20, there was a previous can 19.
Sir,
so therefore, my lord, I don't repeat.
I understand your contention that when the division bench, while disposing can 20 as well as similar type of earlier interlocutory application, have debarred the commission from holding any further examination, the only ratio or can be the only ratio rather only conclusion drawn from the said orders that the ratio that the but by no stretch of imagination the commission can hold any second examination.
Well, just only one additional sentence. In their entire submission, Milord, there is an attempt to, Milord, if I may use this word with caution, to hoodwink this court by suggesting that whatever they have done is correct. In the light of this simple fact, Milord, they have not been.
Mr. Bhattacharya, don't enter into the facts, sir.
It
has been placed.
In their submission, they have not been able to, Milord, justify as to what prompted them. According to
I understand.
Those
come to the next.
I do not want to supplement.
I understand. Come to the next point, Mr. Bhattacharya.
Whatever distinction insofar as the judgment cited at the bar, Milord, I don't propose to deal with them because, Milord, what we learned when we were dwelling in the chambers of my learned senior, Milord, that one single difference on facts makes a world of difference between two conclusions reached in a judgment. Milord, the proposition is a single difference on facts makes a world of difference between two conclusions, and judgments cannot be read as Euclid's theorems. Milord, those two propositions are well settled. They need not be, Milord, cited at the bar. Milord, it flows from Quinn versus Lytham, Milord, the English judgment. From there, Milord, this principle emanates, and Milord, it has been accepted by the Indian judiciary to the extent that a single difference on facts makes a world of difference between two conclusions. Number one. Number two, Milord, a judgment, this judgment, a submission has been made that judgments cannot be read in that fashion. It is not, Milord, then if I could have understood that this point was never raised at the bar, it was never raised in an application. When a point is raised and is rejected, the point is refused. And therefore, by no stretch of imagination,
so it has set as rest. I understand.
Those are, well, I do not want to multiply.
Anything more? Thank you. Any other?
Well, I am not, unlike Mr. Chatterjee, who will go on for 3 days on this. আপনি চলুন ওখানে, আপনি তো আমাকে ওখানে দেবেন, এখানে চলুন। Mr. Vikas Ranjan, he is our leader. Maybe he is my other side.
Mr. Samim will argue.
Yes. I not argue the question.
Mr. Firdaus Samim. Will conclude.
If my senior
no.
says I can.
No, Mr. Bhattacharya will not get the chance of reply. You have to reply.
Let him contradict himself.
What I learned from my guru, I want to use it against my guru.
You are in WPA?
In WPA 26237. 267 of 2024.
7 of 2024.
Yes, my lord. Vasudev Bej.
Your name of your spelling is Firdous.
SAMIM. Firdaus Samim.
SAMIM.
my lord, I formulate my point because of that, my lord, which fallen from the court which was argued by learned senior, my lord. Deal with wants to deal with which fallen from the court. That is why Madrasa Service Commission not preferred the review. That was the question. I believe no one gave the answer. So I want to give the answer it first. Why they not file the review before the division? They scrutinize the matter. They feel so that would be a bad decision. That's why they're not filed.
Sorry?
That would be a bad decision to file a review before the division bench. That's why they not filed it. Why I say so? It seems to that a new evidence might be came because of that a new fact 74,000 left out candidate is there. It seems to be a new fact, but that was not the new fact for the Madrasa Service Commission before the division bench, because in Can 20 they expressly says in para 3. I want to read just that paragraph, nothing more, nothing less, my lord. That is which is annexed with
And 20,
yes, time and again it is there. Yes. Can 20 page number 152. It starts from page number 152 and specific paragraph para 3. I just read the 5 line, my lord, because that was the new fact.
It is Can 20 of 2000.
Can 20 of 2024 in mat number 907 of 28.
Para
3. May I read, my lord? The appellant state that on 12 September 2023, during the pendency of such application, the had already taken a policy decision to conduct fresh written examination of a total of 1,01,064 candidates. That is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written examination of
the Honorable Division Bench unable to comprehend.
Yes, my lord, that was the fact in Can 20. On the basis of that fact, the order passed by the division bench on 13 June, my lord. I want to read on 12 September order and 13 June order, and in the interregnum period, Supreme Court order, which my learned friend, learned senior, my lord, time, yes, Mr. Bhattacharya, time and again says, my lord, that's the very important thing. That is very important thing. I want to read 12 September order, my lord. That is the main order, because Can 20, that doesn't mean there are 20 time extension. No. In MAT 807, there are several addition of party application. Factually in the year 2018, my lord, the first time court order that published the marks. Result. That was the first order. In the meanwhile, they not complied it. They preferred an appeal for extension of time. Sir, why? Because that fact is important. The point, the fact is very important. In the meanwhile, COVID came. They prayed again on the score of COVID. They want an extension of time. And in the Can 20, after disposal of the appeal, they prepared an application on the score of that. The new fact came out first time in Can 20 after 12 September order.
Which is the basis of the whole second written.
So it is not a matter of obiter dicta. It was a fact. On the basis of that fact, division bench passed the order. So that is the reason they not prepared the review application. That's the reason. And very reasonably, they not prepared the review. Now, my lord, the very next point is, sorry.
Yes.
Now, my lord, I came to the argument preferred by which is argued by the Madrasa Service Commission, being a model selector. He wants to be a model selector, no doubt about it. This is they have error or mistake, and that mistake is a bona fide mistake. They have to prove it bona fide mistake. Now, my lord, I want to interpret in mathematical. 26,000 candidate was assessed. This says left out candidate is 74,000, but almost 75,000. So 3 times. So if I represent it mathematically, that means 300% error is there. If I represent it mathematically, they wants to remediate it by another mistake. Well, is it tenable in the eye of law? Third point, which came in my lord this court mind, that standard and the normalization. This says we follow and we want to give some remedy to the left out candidate being a model selector by arranging another written examination.
No, I will not allow you to enter.
I am not argued, my lord. I just said the law point, which on the basis of which fact I will not, my lord, argued in the factual aspect. I just what my lord's mind came, that's the reason. So this says we maintain the same standard, which is very, very evasive word, but it's have a huge implication. Why? Because of that, my lord, it might be, it seems to quote that the same standard. I just put an example. I just wants to give an example. Suppose, my lord, in a examination, suppose there are 2 examination held. In one examination, it is the question was there, what is the capital city of India? Everyone knows New Delhi. In another sets of paper, it was said, what is the capital city of Ghana? May I say that these 2 are the same standard? If that question is what is the capital city of Bangladesh, that is same.
It is not so.
It
is not so, Mr. Sami.
In this score, the Supreme Court verdict is very specific. I don't want to cite but the Supreme Court, what is the settled position of law? Judges are the expert of expert, but judge is not the expert. And Supreme Court time and again says, I don't want to mention that, don't want to cite it. The fact is that Supreme Court says judges should restrain themselves to overstep and put the in that field of academician. That is the complete academic field and expert field. Now, my lord, being an officer of the court, always we have to search the remedy. What remedy remains? Being before a model selector. I formulate this in 4 manner. The first option, what option there? First option that we stick in our stand in respect of Madrasa Service Commission, that is, we will arrange 74 an examination, another examination for 74,000 candidates. That is one option, what they did. Another option might be that according to the division bench judgment, we will not hold examination. That is option B. Option C would be, we will set aside everything and we will start it de novo. That would be the best option. Why? I open my submission with a word. In our country, no one have that right of employment. But equal opportunity in public employment, that's the fundamental right. In anyone's mind, if it is came, it might be error. It is 2 types. Either it is a malafide error, malafide mistake, or bona fide mistake. Whatsoever might be. The third option is the fruitful error. Now, my lord, I came to the argument which is prepared by a very esteemed senior, that is Anindya Mitra. He says, in that decision, we are not the party to the proceedings. So, that would be not a right thing. Cancel the whole proceeding. I put this question to myself, whether any right accrued. It is well settled, mere inclusion in the merit list or mere recommendation does not create any right in their favor. Until and unless you are in employment, that is state. So, now, my lord, the 4 point that is regarding unsuccessful. Time and again, because there are whisper. How you assess me as an unsuccessful candidate? Because I succeed in the preliminary examination. Thereafter, I sat in written examination. Thereafter, you bring 300% erroneous decision.
You don't enjoy that.
So, my lord, my respectful submission in this score, my lord, the court must restrain themselves, must not overstep in the foot of academician. And my lord, my respectful submission is that do justice to everyone. And the fittest justice in this score would be giving opportunity to everyone and put everyone in the same footing. Now, the question is that court take that decision, is anyone's right will infringe? The answer is that no one right will infringe because till date, no one right accrued. That's the reason. The best decision would be in this fact would be put because we are now neither is no one is in this process. In this process, no one is successful, no one is unsuccessful. Till date, everyone is in same footing. Now, my lord, proceed this selection process by putting everyone in the same footing. That's my respectful submission.
The best option would be to hold a fresh examination.
Yes, tenable. And same thing happened in the case of upper primary. In the before.
Sir, no side talk, please. It's very unparliamentary. It is within his right, and the court has asked him a question. He will reply. Don't make a reply.
In this score, I want to, although I will not cited it because it is reply. But in upper primary selection pieces in our state, and another thing I just want to, in the year 2009, selection process, what happened, because my learned
sir, I don't
friend,
require,
because I want to, regarding
no, sir, I will not hear.
Assam matter.
Mr. Ahmed, please come.
Just Assam matter. I just want.
No, sir, I will not hear you, sir.
As my lord, I am extremely grateful, my lord, for patience.
2 minutes. As I have
What's your WPA number?
9578.
2024. Yes, sir.
Lad, 3 of my submission, as I have understood, lad, not replied by anybody. One is in the order of Justice Pratik Prakash Banerjee, they have given reason. They cannot supplement now. This first part, Rashid has recorded that. Second, the order challenging this notice. There was an interim order passed by Justice Amrita Sinha restraining them from conducting any further election test. Whatever they have taken is nullity because in violation.
That you have stated.
And third, nobody has challenged the result that was passed earlier. None of them who has now joined after participating based on the fresh.
Which result?
The first result in which I was declared qualified, written test, and they were not. That result was nobody has challenged. Now, after publication of fresh notice this year, after participating, they have come that we have accrued right. But they have accepted that result. Nobody has challenged.
That you have stated, sir.
Now, in reply, I have twofold of submission. One, this has come from their end, that's why, that there cannot be 2 tests. In the first phase, there was the different category of question papers, A, B, C. The questions were same. The series was different. Different series was there. Here also, different series was there. Question paper in this series, in this set, and the question paper of that set was different. Therefore, test is unequal. In any event, we have come before the writ court. Writ court is not considering the decision, rather the decision-making process. This selection process cannot be never-ending process. If tomorrow they find after interview that there was a lacuna in other process, whether they will return back and conduct again, then the process of selection will be never ending. This can't be. In judicial review, court has to look into whether this decision is arbitrary or not by making it never ending. That's all.
Anybody? Any more? Complete? Very good. Take down.
We are everyone extremely grateful because
My lord.
they said they are because of the corridor is there. They are satisfied. Really,
না না আমাদের তো দেবো Yes. Take down. My lord, passed September and order passed in the month of 2011. No, no, no. দেওয়া উচিত না না এখানে সবাই আমরা কিন্তু একটাই কি কি গেটফুল গেটফুল হলো